Welcome to San Joaquin College of Law Today, a show dedicated to issues and events within the law school which are of general interest as well. SJCL Today is produced by San Joaquin College of Law, a nonprofit law school in Clovis, founded in 1969 to provide quality legal education. Over 88% of its graduates have passed the California bar examination. More than a quarter of the practicing lawyers in the Fresno area are San Joaquin College of Law graduates. Today's show features the lecture, Let's Impeach a President. It always worked before. That was the title of this year's Constitution Day event, presented by San Joaquin College of Law Constitutional Law Professor Jeffrey G. Purvis on September 19th. In the past, his topics have included, is it constitutional for me to scream at town hall meetings so that no one else can be heard? And death panels are trying to kill my grandma.
Welcome to San Joaquin College of Law's Constitution Day and Citizenship Day celebration for 2019. I'd like to begin by recognizing notable faculty and other important people. First of importance, of course, is my lovely wife, Susan, a graduate of this institution, now practicing in the Fresno area. Dean Atkinson, Professor Goodrich, thank you very much for coming up. Member of the Board of Trustees, Jesse Molina, thank you, sir. And Justice Scalia, thank you. This is the 14th annual Constitution Day celebration where you have attended, and I'm deeply honored. Title 55, Section 88 of the United States Code requires that the following statement be read prior to any presentation by Jeffrey G. Purvis. Quote, Professor Jeffrey G. Purvis makes frequent use of sarcasm and irony. SJCL apologizes to everyone offended by his remarks. Although he appears to be an angry white male, Professor Jeffrey G. Purvis is a traitor to his race and to his gender and cannot be trusted. Any opinions expressed by Professor Jeffrey G. Purvis are his alone and do not represent the opinions of SJCL, the State of California, the National Straight Pride Coalition, the Constitution Party, or any other group full of good people who are right-thinking white Americans. Close quotes. I thought that would have gotten a bigger laugh. As any of my former students can tell you, I am psychic. I can read my students' minds to determine whether they are understanding the material that we discuss in class. I will now read the minds of this audience. I'm getting a message from someone, I believe the initial is JBA, and that person is thinking, do we still celebrate the Constitution of the United States? I thought President Trump canceled that by executive order.
I was thinking that. JBA.
Oh, was it you?
Yes.
Thank you, JBA, for thinking that question. You are not correct. The current administration has only eliminated or proposed eliminating select portions of the Constitution, such as freedom of speech for Democrats, freedom of religion for non-Christians, birthright citizenship for people of color, and other outmoded remnants of a decaying society full of losers who thought they could maintain Western civilization using babies that were not white. An important reason we are here today is that in 1952, Congress issued a joint resolution designating September 17th of each year as Citizenship Day to commemorate the formation and signing of the Constitution in 1787. Civil and educational authorities were urged to include, among other things, the complete instruction of citizens in their responsibilities as citizens of the United States. In 2004, Congress changed the designation of this holiday to Constitution and Citizenship Day in legislation that also required institutions receiving federal funds to hold this annual event. So here I am to instruct you on your responsibilities as citizens. Your first responsibility as citizens is to impeach the President of the United States. I jest, of course. American citizens are not permitted to impeach anyone. Article 1, Section 2 of the Constitution says in part, quote, "The House of Representatives shall have the sole power of impeachment," close quotes. Article 1, Section 3 states in part, quote, "The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside. And no person shall be convicted without the concurrence of 2/3 of the members present. Judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nonetheless be liable to indictment, trial, judgment, and punishment according to law," close quotes. And Article 2, Section 4 states in part, quote, "The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors." Like so much about the Constitution, this discussion starts out straightforwardly and rapidly becomes Byzantine. One way of thinking about this process is to regard the term impeachment as analogous to prosecution, where the House of Representatives plays the role of the prosecution. Impeachment charges the person at issue with wrongdoing, something like a crime, although, as I will discuss in a moment, what constitutes an impeachable offense is a subject of great controversy. Continuing this analogy, the Senate is the court in which the impeachment is resolved, and the senators are the jury. The Chief Justice of the United States is the judge presiding over this courtroom. But unlike an ordinary trial, the jurors, the senators, decide how the trial shall be conducted. To obtain a conviction on the impeachment, 2/3 of the senators present must vote guilty. A notable difference between impeachment and a criminal trial is that in the latter, the prosecution must identify some violation of the criminal law allegedly committed by the defendant. As indicated previously, impeachment of the president must be on the basis of treason, bribery, or other high crimes and misdemeanors. Treason is explicitly defined in Article 3, Section 3 of the Constitution. Quote, "Treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act or on confession in open court." Close quotes. Bribery is the offer or acceptance of anything of value in exchange for influence on a government or public official or employee. The elements of these offenses would undoubtedly be the subject of some dispute in an impeachment involving either, but they do focus the debate relatively narrowly. In contrast, high crimes and misdemeanors is a spectacularly ambiguous phrase. As I frequently point out in our annual get-togethers, the entire Constitution is spectacularly ambiguous, and thus in determining what the highest legal authority of our nation provides, the courts must constantly interpret its provisions. And despite judges' oft-cited principle of the plain meaning doctrine, which requires that interpretation begin with the ordinary meaning of the words being interpreted, it is rare for a constitutional provision to have ordinary meaning on which interpreters can agree. One might think that the term misdemeanors would have a settled meaning, but because the drafters of the Constitution were writing 2 centuries ago, long before criminal law labeled more serious crimes as felonies and less serious crimes as misdemeanors, the modern classification is not informative. In addition, it doesn't make sense for the Constitution to have chosen treason, bribery, and other high crimes as impeachable offenses, and then to add less serious crimes to the list, unless the framers simply meant that any wrongdoing could trigger impeachment. An often used canon of interpretation says that where lawmakers provide a list of specific things to be regulated, then add a generic catch-all category, That category is presumed to include only those other things that are equivalent to the specifically identified items. This suggests that high crimes and misdemeanors must have been intended to include wrongdoing that was of equivalent seriousness to treason and bribery. Some scholars have supported this analysis by pointing out that in the 16th century, demeanor was used as a synonym for behavior, and misdemeanor therefore meant wrongful behavior. On this reading, other high crimes and misdemeanors would mean other serious crimes and serious wrongdoing that did not literally amount to a crime. An interpretive approach called originalism often seeks to identify constitutional meaning from historical evidence on the justification that contemporary practices and what the framers said about what they were writing provide the best evidence of how they believed a particular constitutional provision should function. In my opinion, this ignores the fact that the framers were merely the drafters of the Constitution. They did not have authority to make it the governing law of the land. The decisions of the propertied white males who were allowed to vote on ratification in the sovereign states are the only legitimate source of philosophical justification for interpreting the political decisions that created the Constitution. And we can hardly ask those long-dead racist, sexist homophobes what they were thinking. The only plausible basis for privileging the historical records of the framers in constitutional interpretation is to assume that the voters who ratified the Constitution all understood the provisions in the exact same way the framers did. An unsupportable assumption in my view. And it must also be accepted that what was in the collective mind of the voters, derived from the historical evidence of the drafting process, should be privileged over any other understanding of the provisions of the text. In the edutainment context of our constitutional celebration, I will summarize the historical evidence scholars have unearthed as follows. Impeachment originated in England as a stratagem by Parliament to attack Crown officials with whom it had disagreements. English impeachments were applied to both serious wrongdoing and to, as one scholar wrote, petty acts of maladministration which no sensible person would think impeachable offenses. The framers considered limiting impeachment to treason and bribery, but there was objection that many serious offenses that should be impeachable would not fall within those specific terms. So they added the other crimes and misdemeanors language, which had commonly been used in England to describe impeachable conduct. Many constitutional scholars conclude that impeachable offenses are those abuses of power or injuries to the nation that can only be committed by public officials by virtue of their public offices or privileges that they hold. They characterize these as political crimes and emphasize that there is no requirement that the offense actually be prohibited by the criminal law. The question of what wrongful conduct is a proper subject of impeachment leads to a related issue that is frequently encountered in discussions of historical impeachments. Since the House of Representatives determines whether to impeach and what the charges of impeachment will be, it is conceivable that legislators hostile to a president because of political disagreements could use the impeachment process to remove or weaken the president for primarily partisan purposes. If the same political party controlled both the House and the Senate, obtaining a conviction on whatever charges the House selected might similarly be motivated by political views, rather than a neutral consideration of whether impeachment charges were legitimate or sufficiently proven. It is instructive to note the historical attitudes of members of Congress as to this issue. Representative John Randolph, a supporter of President Jefferson, argued that the House of Representatives could define impeachable offenses as it wished. In 1970, Gerald Ford, then House Minority Leader, said, quote, "An impeachable offense is whatever a majority of the House of Representatives considers it to be at a given moment in history," close quotes. Don't close them yet. Conviction results from whatever offenses 2/3 of the Senate considers to be sufficiently serious to require removal of the accused from office, close quotes. During the impeachment of President Clinton, Tom DeLay, the House Majority Whip, echoed Ford's language, saying that a high crime or misdemeanor is, quote, whatever a majority of the House of Representatives considers it to be at a given moment in history. For whatever reason, influential members of Congress have apparently rejected the scholars' opinions I previously discussed that impeachable offenses are restricted to serious abuses of power or other injuries to the nation. As a law professor, I enjoy creating fanciful exam fact patterns to challenge my students' legal and analytical skills. They're enjoying it right now. Imagine that in the national election of 2022, after President Elizabeth Warren's first 2 years in office, a political backlash is initiated among angry corporate executive white males because of her relentless promotion of equal rights for women and protection of consumers. Using their control of immense wealth, these ACEWMs form a coalition of white nationalists who hate Warren for her impure blood, plutocrats who hate Warren for proposing regulations that restrain their obscene greed, and bitter Trumpian loyalists who hate the fact that Warren closed the immigration detention camps and reinstated compassionate asylum and DACA policies. This coalition enables Republicans to take control of the House and the Senate. Aided by the Supreme Court's evisceration of voting rights for people of color and Democrats, that part's not imaginary, the reinvigorated Republicans command a more than two-thirds majority of the Senate. The House then brings impeachment charges against President Warren for falsely claiming to have Native American ancestors. And following a brief reading of the charge in the Senate, the senators present find her guilty by acclamation. Using my well-known telepathic powers, I sense many audience members thinking, that's crazy, where does he come up with this garbage? And now many of the audience are thinking, wait, we thought it was crazy when people said Trump would support Nazis and evil dictators and would lock immigrant children up in cages. I believe we have all just experienced a concept known as the new normal. Back to my story. Those of you who have studied constitutional law will immediately spot an issue in this fact pattern: procedural due process. Whenever the government deprives a person of life, liberty, or property, it must act according to constitutional requirements of procedure. And one immutable requirement is that the person suffering the deprivation must have been given some opportunity to be heard as to the propriety of that deprivation. Because in my imagination, the Senate voted to convict on the impeachment without giving President Warren any chance to defend herself, depriving her of her interest in remaining in the office to which she was elected by the people, the conviction on the impeachment is unconstitutional. You may applaud. I think this demonstrates that my perfervid concerns about a hyper-partisan use of the impeachment process are manifestly overblown. Wouldn't you agree? However, a partisan Congress might abuse the process of impeachment. Constitutional guarantees of procedural fairness and substantive fundamental rights will prevent legislative overreach. If any of you did agree with the preceding statement about constitutional rights in impeachment proceedings, I can only say, oh, you sad, deluded fools. The United States Supreme Court, guardian of our liberty, has removed consideration of constitutional rights from the process of impeachment. In 1993, the court decided Nixon versus United States, which involved the impeachment of a federal judge, not the infamous President Nixon. Federal judges do not seem to fall within the category of civil officers of the United States mentioned in Article 2, and thus might be thought inappropriate targets for impeachment. But Article 3 provides that federal judges hold their offices during good behavior. And on the theory that impeachment was an appropriate method to remove judges from office who engaged in bad behavior, Congress has more than once impeached and convicted judges. Judge Nixon had been convicted of a crime and sentenced to prison, then was impeached. the Senate permitted a committee of its members to hear evidence on the impeachment and then to report that evidence to the full Senate. After the committee reported, the Senate voted to convict, and Nixon was removed from his judicial office. Judge Nixon filed suit in federal court claiming that the process the Senate used was not a trial, and therefore violated the constitutional text that gives the Senate power to try all impeachments. You will recognize that this challenge is different from the due process claim I imagine President Warren would make, but the decision reached in the Nixon case obviates any distinction. This is because the Supreme Court held that the manner in which the Senate carries out its constitutional power to try impeachments is a political question, meaning the courts have no jurisdiction to decide any issue relating to the conduct of the Senate trial. Similarly, the High Court decision strongly supports the principle that the House of Representatives is not subject to any judicially conducted constitutional oversight when it makes a decision to impeach. Thus, President Warren and any president, officer of the United States, or federal judge appear to hold office subject only to the will of Congress. Having sketched out some of the interpretive issues surrounding impeachment, let's examine the few historical examples of presidential impeachments to seek insights into how a Trump impeachment might proceed. The first president to be impeached was Andrew Johnson. Johnson was a member of the Democratic Party, was a senator from Tennessee when the Civil War began. Lincoln had won the presidency with 40% of the popular vote in 1860, in part because the Democratic Party ran 3 separate candidates against him. Johnson was a slave owner and a racist. As president, he said African Americans were unfit to vote and were inferior. In 1866, he vetoed the Civil Rights Bill, but was overridden by Congress. And he opposed adoption of the 14th Amendment. Johnson was added as Lincoln's vice presidential running mate in order to appeal to Democrats in the northern states. After Lincoln was assassinated and Johnson became president, he fought against the Reconstruction plans of the Republicans in Congress and advocated readmitting the treasonous Confederate states largely without conditions. Republicans in Congress sought to prevent Johnson from replacing Republican officers in the executive branch by enacting the Tenure in Office Act, which required Senate approval if certain officials were to be dismissed. The act made it a crime punishable by imprisonment if the president violated its terms. 3 days after President Johnson dismissed Edwin Stanton, who had been Secretary of War under Lincoln, the House of Representatives voted to impeach Johnson. The articles of impeachment focused on Johnson's violation of the Tenure in Office Act, but also charged him with, quote, trying to impair and destroy the regard and respect of all the good people of the United States for Congress, and to excite the odium and resentment of all good people of the United States against Congress, close quotes. Johnson was further accused of, quote, making and delivering in a loud voice certain intemperate, inflammatory, and scandalous harangues with loud threats and bitter menaces against Congress. Geez, I'd be guilty of doing that to the Supreme Court, if suddenly occurs to me in class. After trial in the Senate, the vote to convict President Johnson was 35 to 19, 1 vote short of the required 2/3. 7 Republican senators voted to acquit, and historians suggest that some of the Republican senators who voted to convict were prepared to instead vote for acquittal if it appeared that the necessary 2/3 majority would otherwise have been achieved. Were the impeachment charges against President Johnson for serious political crimes? Or was the impeachment an example of a partisan attack by the House of Representatives against a president regarded as a political enemy? Johnson's defense included the argument that the Tenure in Office Act was unconstitutional, and it would certainly be considered so by present-day constitutional standards. The only non-tenure in office act related impeachment charge was a preposterous condemnation of Johnson's political speech activities. It is difficult not to conclude that the impeachment was a partisan attack fueled by Republican anger at Johnson's manifest sympathies with the defeated Confederates and his willingness to restore the political power of white Southerners. Some commentators offer a more political perspective on voting in the Senate, however. Without going into the details of the politics of a century and a half ago, suffice it to say that potential candidates for the next presidential election included Salmon Chase, who was, as Chief Justice, presided over the Senate trial, Senator Benjamin Wade, who as President pro tempore of the Senate would have become President of the United States if Johnson had been convicted, and Ulysses S. Grant, who was chosen as the Republican nominee for president during a recess called for that purpose in the Senate trial of the impeachment. Thus, some historians suggest the decision to impeach and the vote to acquit were strongly influenced by the impact those decisions might have had on the future political fortunes of the participants. The second presidential impeachment in U.S. history targeted William Jefferson Clinton. For those of you to whom the events of the late 1990s are ancient history, I will very briefly summarize the events that led to Clinton's impeachment. A very wealthy conservative person funded a campaign asserting that Bill and Hillary Clinton were leaders of a criminal syndicate and that they had murdered a White House aide named Vincent Foster in order to conceal their crimes in connection with a real estate deal called Whitewater. The Attorney General of the United States, Janet Reno, appointed a special prosecutor, Robert B. Fisk, to investigate these allegations. Fisk ultimately reported that Foster had committed suicide. A special prosecutor statute that had been enacted after the Nixon-Watergate era had expired, but was reenacted, which had the effect of terminating Fisk's appointment as a special prosecutor. Kenneth Starr was subsequently appointed as a special prosecutor with authority to reopen the Foster murder investigation. On October 1977, Starr issued a report concluding that Foster had committed suicide, and Starr later reported that there was insufficient evidence that the Clintons had committed any crimes in connection with the Whitewater deal or in other circumstances in which there had been allegations of criminal conduct. However, in the course of a lawsuit by Paula Jones against President Clinton for sexual harassment, which suit was subsequently dismissed for lack of evidence on summary judgment, President Clinton was deposed and denied having sexual relations with the White House intern, Monica Lewinsky. Special Prosecutor Starr subsequently called President Clinton to testify before a grand jury and asked the president whether he had lied about sex with Lewinsky in the Jones trial deposition. Clinton denied this. It was later revealed that Clinton had engaged in sexual relations with Lewinsky and had lied under oath about it in the deposition and before the grand jury. On November 19, 1998, Starr testified at a House Judiciary Committee hearing during which he argued that President Clinton should be impeached. The Republican members of the committee, including the chair, gave Starr a standing ovation at the conclusion of his testimony. In December 1998, the House of Representatives adopted 2 articles of impeachment against the president, charging him with perjury before the grand jury and with obstruction of justice by concealing evidence in the Paula Jones litigation. Trial began in the Senate on January 7, 1999, and on February 12, 1999, the Senate voted 55 to 45 to acquit on the perjury article and 50 to acquit and 50 to convict on the obstruction of justice article, both far short of the 2/3 vote required for conviction. Because of the vitriol that characterizes politics, particularly on the Republican side, it undoubtedly remains controversial in an important sense whether the Clinton impeachment was, in the terms I have used today, for serious political crimes affecting the nation, or was a partisan attack. Lying under oath is a serious act of wrongdoing. Lying under oath about adulterous and arguably oppressive sexual conduct is not something that I would characterize as an abuse of power or an injury to the nation that can only be committed by public officials by virtue of the public offices or privileges they hold. The mountains of evidence documenting the years-long efforts by conservatives to attack President Clinton reveal his impeachment as simply a culmination of or stratagem in a calculated partisan campaign. With regard to an impeachment of Donald Trump, I think two questions are most important. First, has he committed an abuse of power or an injury to the nation that can only be committed by public officials by virtue of the public offices or privileges they hold? Second, how does the alleged wrongdoing Trump has committed compare to the wrongs claimed to support President Johnson and Clinton's impeachment or other relevant impeachment circumstances? In my view, there is objectively reasonable evidence, even if Trump did not personally interact with Russian agents, that he permitted and encouraged members of his campaign to do so in hopes it would benefit his candidacy. Even aside from his public statements that he hoped Russian hackers had succeeded in obtaining emails of his opponent, Hillary Clinton, and that he believed Vladimir Putin's denial of Russian election interference, Trump has willfully ignored the reports of United States intelligence agencies that Russian hackers sought to influence the 2016 presidential election. And he continues to deny and ignore similar warnings that Russia intends to interfere even more in the 2020 election. Trump attempted to frustrate any investigation into Russian involvement in his campaign by attacking Attorney General Sessions for recusing himself, by seeking to dissuade FBI Director Comey from pursuing an investigation of Michael Flynn, by firing Comey when the latter refused to be dissuaded, and by attempting to terminate Robert Mueller as special counsel investigating Russian influence and obstruction of justice. These are serious political crimes as defined previously, and at minimum support consideration and investigation of impeachment by the House of Representatives. If U.S. military authorities reported that Russian agents surreptitiously entered the United States, kidnapped several U.S. citizens, and took them to Russia, and President Trump responded that he had asked Vladimir Putin whether that report was true, and Putin had denied it, and Trump said he believed Putin and took no further action to investigate or otherwise seek to recover the kidnapped Americans and prevent future kidnappings, would you regard that as a sufficient wrong against the nation to justify impeachment? Would it be sufficient if the Russians had kidnapped 100 Americans or 1,000 Americans? Assuming for the sake of analysis that Russia did interfere in the 2016 elections and had both the intention and capability to engage in even more interference in the 2020 elections, sufficient interference to potentially alter the outcome of the presidential election, would you consider that a roughly equivalent in harm to the kidnappings I mentioned? Any reasonable person would say at a minimum that a thorough investigation of either situation should be conducted. Recall that the claim that Bill and Hillary Clinton had murdered a White House aide was made the subject of two separate special prosecutor investigations. But our politics has become so poisonous and the impact of confirmation bias has become so powerful that a significant portion of the American electorate is willing to disregard a dangerous threat to our democracy, in part because the election interference may have helped elect their preferred candidate. The claim that there is a violation of the Foreign Emoluments Clause when foreign nations pay to utilize properties owned by Trump, such as hotels and resorts, also qualifies as a serious offense against the nation, in my opinion. There is widespread agreement among scholars that the Emoluments Clause, which forbids acceptance by the President, quote, of any present, emolument, office, or title of any kind whatever from any king, prince, or foreign state, close quotes, addresses a concern that transfers of economic value from foreign nations or other actors could constitute a danger that the decisions of the President receiving them would be shifted to favor those foreign nations. This reflects an understanding that buying influence in modern terminology can be accomplished without utilizing the explicit quid pro quo of a bribe. For example, during Trump's presidency, the governments of Kuwait, Saudi Arabia, Turkey, and Georgia, among others, have bought rooms or held events at a District of Columbia hotel owned by Trump. Previous presidents have sold their property interests or transferred them into a blind trust operated by an unrelated third party in order to avoid the influence buying implications of such ownership. Trump refused to do so, instead transferring his properties to a trust managed by his adult sons. The justification offered for this was that Trump's properties were so extensive that selling them or utilizing a blind trust would have been too difficult. I think we can all understand how a trust managed by an expert third party would be much more difficult to accomplish than a trust managed by Donald Trump Jr. and Eric Trump, men whose business acumen is legendary. Are Trump's support of Saudi Arabia's bombing operations in Yemen, resulting in tens of thousands of civilian deaths, and Trump's support of Mohammed bin Salman, the Crown Prince of Saudi Arabia, despite credible allegations that bin Salman ordered the torture and death of journalist Jamal Khashoggi, influenced by the profits generated by Saudi Arabia's use of Trump's hotels? The danger of these potential emolument clause violations may not be as serious as Russian election interference, but surely warrant a thorough investigation by the House of Representatives. I do not regard Trump's support of Nazis, Ku Klux Klansmen, and other white nationalists, his thousands of lies, his attacks on the press, his encouragement of violence, his threats to regard election results, his false declaration of a national security crisis arising from refugees seeking asylum from murderous gang violence, his cruelty to children, his alleged violation of campaign finance laws, and his alleged tax code violations as impeachable offenses. Those should be the subject of electoral punishment, but I have nearly abandoned hope that this will ever occur. As to my second question, comparing the alleged wrongdoing Trump has committed to the wrongs claimed to support President Johnson in Clinton's impeachment, Johnson was impeached for violating a patently unconstitutional statute and for expressing disagreement with his political opponents. Clinton was impeached for lying under oath about adulterous sex in a deposition and then lying under oath in a grand jury proceeding about the previous deposition, again involving adulterous sex. In both of these previous impeachments, there can be no plausible claim that serious injury to the nation or its self-governing nature were at issue. Trump's ongoing willingness to overlook the election interference of a dangerous foreign adversary of the United States is a direct threat to our political system and to the foundation of our government. Trump's attempts to prevent any investigation into the above threats are much more serious than the cover-up of the Watergate burglary by President Nixon that resulted in such a high probability of impeachment and conviction that Nixon resigned from the presidency rather than face the near certainty that senators from his own party would vote to convict. Thus, even a person who believed that neither Johnson nor Clinton should have been impeached could reasonably argue that Trump should be impeached. As to anyone who felt that it was appropriate to impeach Clinton, I am thinking of the Republicans in Congress then and now, it would be unreasonable to claim that the alleged wrongdoing by President Trump is not an impeachable offense. Other than tuning into Fox News, where I'm sure we would find an impassioned defense of Trump, what arguments can be raised against his impeachment? That the 200-page Mueller report and the numerous public comments and actions taken by Trump do not conclusively prove that he permitted and encouraged Russian interference in American elections? Whether an investigation provides conclusive proof of wrongdoing is not determinable by a reading of a redaction of that investigation. This is determined by prosecution and trial. It is just as erroneous to conclude that Trump is not guilty and thus prevent a trial as it would be to conclude that Trump is guilty and omit a trial. Is it a plausible defense that the credible allegations of wrongdoing by Trump that I have only sketched are solely the product of a partisan Democratic Party attack? This is certainly what Trump and his supporters have said and will say. I thought the capacity of Trump supporters to astonish and dismay me had been exhausted when I saw a video of some of them wearing t-shirts that said, quote, "I'd rather be a Russian than a Democrat," closed quotes. Trump demonstrably operates on the principle that if anyone criticizes him, or if any decision does not go his way, the only explanation is that the person involved are biased because of their race, their nationality, their gender, their politics, or their low ratings. Trump makes decisions based only on what will benefit him financially, politically, or personally, and he assumes that everyone else is doing the same thing. Reviewing the two presidential impeachments, the almost impeachment of President Nixon and the potential impeachment of President Trump, which the House of Representatives is considering now, it appears to me that the first two were largely partisan political attacks, both of which ultimately failed, and that the Nixon threat of impeachment, resulting in his resignation, was a bipartisan action founded upon serious political wrongdoing, an attempt to subvert the process of electing the President of the United States. I have argued that the wrongdoing Trump could be accused of committing is a greater threat to our system of self-government than that of Nixon. Why then does there seem to be such strong disagreement among the Democratic members of the House about whether to proceed with impeachment? The answer reveals how much the answer reveals how much the reality of political action departs from the theory about how the Constitution was intended to work. The voters have an opportunity to correct presidential wrongdoing every 4 years, so impeachment may have been imagined as an emergency measure to address an abuse of power so great and so dangerous that irreparable harm would result from waiting for the next election. Thus, the House of Representatives should act immediately, especially since the danger presented by Trump's conduct is to the electoral process itself. But Speaker Pelosi and her allies must realize that few or none of the Republican senators will ever vote to convict the president. Pelosi must be assessing the political impact of the voters of a failed impeachment. Presumably, she is aware that the Republican Party lost 5 House seats in the election following the failed Clinton impeachment, and may be afraid that a similar negative reaction could result in loss of the Democratic House majority in 2020 and degrade the Democratic minority in the Senate. We have already seen how the framers' fear of a real democracy manifested in the Electoral College, and the Supreme Court's failure to recognize partisan gerrymandering as a violation of the Constitution created a federal government controlled almost entirely by a political party not supported by a majority of American voters. Are we witnessing the end of our constitutional system? I wish I had an optimistic response to that question. I believe that our only chance is to stop spending hundreds of millions of dollars in a futile attempt to persuade voters, and to instead use those resources to motivate and facilitate the voting of as many Americans as possible. You've been a great audience. Thank you. Good night. We do like to allow a period for temperate, moderate, unlike myself, questions or comments from the audience regarding today's topic, if anybody has any. Yes, sir.
I was curious, on the emoluments cases, what's the status and what do you think the chances are?
Well, I'm aware of one case, and the trial court, the U.S. District Judge, dismissed it for lack of standing, saying that the plaintiffs had not suffered a sufficient injury to justify their invoking the federal courts. The Circuit Court of Appeals reversed that. The plaintiffs are other hotel owners and other businesses that claim business has been siphoned away from their businesses to Trump properties in order to influence the president. And so the Ninth Circuit, I don't know what circuit it was, I don't remember, sorry. Anyway, remanded it so that the trial could continue, ruling that they did have standing. So standing is a preliminary issue that's decided long before the merits are approached, so the litigation has kind of been set back to step 2, and we'll go forward from there. I am frankly extremely confident that if the litigation ever resulted in something before the Supreme Court of the United States, that they would find in favor of President Trump. So it's kind of futile, but I applaud and appreciate the people who are willing to undertake that litigation. Yes, ma'am.
Do you think that if the full Mueller report is released, the chances of impeachment are higher if the full report is released on the Mueller report?
Well, assuming that the House has the following purposes, or these are what I think about the House's purposes. I think some of them believe that an impeachment process which would be public rather than something redacted and hidden from the people would generate political support, would energize Democratic voters to vote in the 2020 elections, and would be something that would degrade Trump's political chances. They may also be motivated by genuine concerns that what Trump has done has been very harmful. So both of those purposes would be supported if the entire and complete Mueller report was available to them, and if White House or intelligence agency whistleblower reports that the Attorney General's office have already ruled credible were in fact delivered to the House rather than being held in violation of law by the Trump administration. And anything else that came to light would make the case for impeachment stronger. But in my suburban, long ago, white male heterosexual youth, we would test each other's conviction by asking, are you willing to bet about that? So we would bet for some delicious beverage or a meal or something. I will be willing to bet anyone who cares to take up the action that the Senate will never convict President Trump, regardless of what evidence comes out. He could have, informed Putin that we're going to let Putin annex all of the Ukraine, and they still wouldn't do anything, in my opinion. So, if it aids an airing of the wrongdoing, I think impeachment is appropriate, but I consider it, in terms of actually removing President Trump from office, completely futile. And I'm not an expert on politics, I'm just a regular person thinking about politics. I wonder if Speaker Pelosi or the people who impose impeachment think it would be better to run against Donald Trump in 2020 than against Mike Pence or some other less evil, less wrongdoing Republican. And so, all of that may be part of the calculus affecting the House's decision, seems to me.
I also sort of have an unrelated follow-up question. Why do you think that Mueller didn't conclusively state the findings of his report?
Okay, now we're way outside my area of expertise. But since you asked, for one thing, it's my understanding that Special Prosecutor Mueller did not make decisions because he believed, as apparently the Department of Justice believes, that it is not possible to indict a sitting president, which I'm not sure what their basis for that is. Perhaps the fact that the president has absolute immunity from civil damages while he's in office. I don't think that mean, if President Trump did shoot someone in the middle of Fifth Avenue, which he claimed as a candidate he could get away with because everybody loves him, I do think he could be indicted for murder. But apparently the Department of Justice lawyers don't think so. So he refrained from making a conclusion about the obstruction of justice. He apparently didn't think that there was sufficient evidence to conclude that Trump had personally interacted with Russian agents. So he didn't take any decisive action. He didn't, like Kenneth Starr, when he appeared before the House, say, you really need to impeach this guy. You know, he said very little. I may be wrong here, but I thought Mueller was a Republican. I don't know, but I thought he was. Pardon? Okay, score. And so he may have concerns about burning bridges to his friends and his colleagues, and even to his chances for lucrative employment in the security industry, the private security industry in the future. I don't mean to malign the fellow, but it's difficult to understand why he did what he did because he won't talk about it, clearly. So that's what we get. All right, again, thank you very much for coming, and have a good evening.
And that brings us to the end of this edition of San Joaquin College of Law Today, presented by San Joaquin College of Law, a nonprofit law school committed to educational excellence and community service. The views expressed do not necessarily reflect the position or views of San Joaquin College of Law. This program has been produced in conjunction with the Community Media Access Collaborative. We invite you to join us in the future as we explore issues and events within the law school which are of general interest as well. For more information about San Joaquin College of Law, please visit our website at www.sjcl.edu or call 559-323-2100.